Good afternoon. Welcome to this discussion on the PAIA Act. My name is Shireen Oftir, and I am from the Conduct of Business Supervision Division at the FSCA. And that is quite a mouthful. What it essentially means is that we supervise most of the licensed entities authorized by the Financial Sector Conduct Authority. With me today are two colleagues of the Office of the General Counsel, Kamcilla Naidoo and Ziyanda Mshungane, and they're going to be discussing the PAIA Act and why it is important for us to understand how it affects licensed entities. Ladies, thank you so much for joining me.
Thanks, Shireen.
Thank you, Shireen.
Without any further ado, I'm going to kick off and ask Kamcilla to please explain what is the PAIA Act and why it is important for us to understand what it means.
Thank you, Shireen. Yes, so PAIA stands for the Promotion of Access to Information Act, number 2 of 2000. What it actually does is supports the constitutional right of access to information as contained in Section 32 of the Constitution. Now, the FSCA is a public body as defined in the PAIA Act. And what this means is that anybody, any member of the public seeking records that are held by the FSCA may bring a PAIA request to the FSCA. Now, both Ziyanda and myself belong to the Office of General Counsel. And the Office of General Counsel is also what we previously used to refer to as the legal department of the FSCA. And that is where PAIA is currently housed within the FSCA. Thanks, Shireen.
Thanks, Kamcilla. Now, Ziyanda, as Kamcilla has mentioned, you're at the Office of the General Counsel and you are responsible for dealing with the PAIA Act on behalf of the FSCA. I'm sure that in this Act, as in many other pieces of legislation, certain people are defined as having specific duties. Could you take us through a little bit of that, please?
Sure, Shireen. Well, there are 3 key role players for purposes of PAIA. Firstly, the Commissioner of the FSCA is the Information Officer. And as the Information Officer, he is statutorily enjoined to ensure that the FSCA, as a public body, complies with the provisions of PAIA. And as the Information Officer, he has also appointed 2 Deputy Information Officers, being myself, Ziyanda Mshungane, as well as my colleague, Kamcilla Naidoo. And as Deputy Information Officers, ours is to consider and process PAIA requests for access to the records of the FSCA. Thanks, Shireen.
Thanks, Ziyanda. 2 ladies are very important. I'm very privileged that you were able to make the time to join me for this discussion. Kamcilla, I know that there is a regulator for this piece of legislation. Could you talk to us a little bit about who the regulator is?
Yes, Shireen. So the Information Regulator, well, that office for the Information Regulator was actually created by Section 39 of the Protection of Personal Information Act 2013. We casually refer to it as PAIA. So previously, that is prior to 30th of June 2021, PAIA fell under the custodianship of the SA Human Rights Commission. But as of 30th June 2021, the Information Regulator now regulates PAIA. So anybody wanting details or information about the Information Regulator can actually just Google Information Regulator and you'd be taken directly to their webpage. And just out of interest, the Information Regulator falls or is part of the Department of Justice. Thanks, Shireen.
Thank you. That's really interesting to see that it is a government function and it falls under a specific department. I know that we have lots of documentation that explains to us how we need to do something. So Ziyanda, could you talk to us a little bit about the PAIA manual that the FSCA has?
Right. So, Shireen, as obliged by the Act, the FSCA has compiled and published a PAIA manual, and this manual is actually available on the FSCA website. And this manual basically serves as a reference point for members of the public as they engage with the FSCA on matters that are related to PAIA. And it actually provides for information such as the contact details of the FSCA, a description of the structure and functions of the FSCA, and the description of the type of records that we hold as an organization. It also speaks to categories of records that are readily available. That is, records that do not require that a PAIA request be requested. Such requests are actually can be sent directly through to a designated mailbox, and from that point on, the requester will be provided with the information. And as a public body, we are actually required to update and publish the manual at intervals of no more than 1 year. And this is something that we do as an organization. Thanks, Shireen.
Thank you, Ziyanda. And I'm glad that you mentioned the process to access information, because I know a while ago we actually had such a request from an FSC who wanted to access certain of their own documents. It wasn't readily available information, and we had to guide them through this process. Kamcilla, you were incredibly helpful in that process. Could I ask you to explain to people how do they go about making such a formal request?
Sure, Shireen. So just to allude to what Ziyanda says, our PAIA manual is very descriptive in terms of the types of records we hold. And specifically, I would request firstly any requester to consult the PAIA manual, look at what information or records are readily available and that they don't have to bring a PAIA request for. And everything that falls outside of that, then they need to bring a PAIA request. And once they've established that, what we require is that the requester must complete a PAIA application form. Now, they may either download that application form directly from the Information Regulator's website, or we've also made it readily available on the FSCA website. And any requester may then download that application form. And what is required in the application form is obviously the name of the requester, and we would want supporting identification of that requester. And what the form also provides for is that you may decide to bring a request, a PAIA request on behalf of someone else. But then on that basis, you must prove your capacity. A typical example is an attorney may bring a PAIA request on behalf of their clients. We would then, in that instance, want a power of attorney, verifying that you, Mr. Attorney, are authorized by your client to bring such an application. Often you would find the type of records may be personal of nature, confidential, and us being a regulator, in all instances, it is confidential. So we would need to, to satisfy ourselves that you're bringing this request on behalf of someone, you are empowered to do so. Once, and obviously in that application form, outline clearly what specific records you are requesting. And once you've done that, you may email that completed PAIA request form to the email address paia_popia@fsca.co.za. Both Ziyanda and myself, we have access to this mailbox, and we have a system that we attend to such requests. There is also a PAIA request fee that is payable, and it's currently 100 Rand. Now, this request fee has been set by legislation. So it's set out in the PAIA regulations. So it is not something that the FSCA imposes, but it is something that is imposed in terms of the Act itself. So a requester, in addition, will have to pay a 100 Rand request fee. So, and once we receive such an application and the request fee, we will assess such an application. And in assessing, we would decide whether access will be granted or whether access will be denied. And of course, it being a constitutional right to have access to information, there will be very specific grounds upon which we as deputy information officers can invoke if we deem such an application or such a request to be declined. So I think I'm going to pause there, Shireen, and let you take the process further. Thanks.
Thank you, Kamcilla. That was really useful. So it's very important to note that not anyone can get access to any piece of information. You actually have to show that you have a reason to access that information and that you have the right to that information. So that aspect of confidentiality that you've also referred to remains at the foremost before we grant access to information. It's not as easy as just asking and you will get. Thank you so much. I think that reassures a lot of people because we sit with a lot of information about people, both individual and legal, and that they have the reassurance that we will deal with the information very circumspectly at all times. Ziyanda, carrying on with this, we talk about the assessment of PAIA applications. What are some of the aspects that you consider when you make such an assessment?
All right, before I go into that, Shireen, I'd just like to expand to what Kamcilla has just mentioned in terms of us granting or refusing requests. So what the Act does is that it obliges us to consider each application and to communicate our decision, granting or refusing the request in writing. And as we consider requests, we are guided by Chapter 4 of the Act, amongst others, which prescribes the grounds for refusal of access to records. And those grounds include, for example, the protection of privacy of a third party who is a natural person, and the protection of confidential information. I mean, as you've just alluded to, this is sensitive information which should not just be unjustifiably compromised. And commercial information of a third party also enjoys protection in terms of Chapter 4. But what does this mean for us practically? What does this entail? Well, where a request for information is in relation to a third party, Section 47 requires us to engage the third party concerned to request for permission to release the information. The third party can, of course, grant or refuse consent, but after considering the response, we are then in a position to make a decision, granting or refusing the request. And as indicated earlier, our decisions will always be communicated in writing to the requester. Thanks, Shireen.
Thank you, Ziyanda. That again just underscores how important we take the request as well as the confidentiality of information. I'm very reassured by it, and I hope that our listeners will also remain reassured by this. I'm sure that you have timelines and constraints within which you deal with this. Kamcilla, do you mind talking us through the timelines and the constraints that you have in terms of how much time you have to respond to a request?
Yes, Shireen. So, PAIA underscores the constitutional right to access to information. And accordingly, we as deputy information officers have to abide very strictly to the prescribed timelines that are outlined in the PAIA Act. And we have 30 days to respond to every request that we receive. And that's on the proviso that the request fee has been paid and that the proof of capacity has been received. And so, there are some specific grounds that are outlined in PAIA, specifically in Section 26, that does allow us to extend the period for access to information, but that is also restricted to a further 30 days. So we cannot extend indefinitely. And generally, you'll find that we at the FSCA, we generally will invoke Section 26 where we receive a request for a very large number of records, or we have to consult among various divisions within the FSCA in order to collate those records. I see Ziyanda is shaking her head because, you know, she had to deal with a huge request this year, and it entailed a lot of consultation amongst various divisions within the FSCA. But that is the nature of us dealing with PAIA requests, and obviously we only can extend such periods based on grounds that are outlined in Section 26. So we do not have a discretion in this regard. And I think requested need to know that, because we take this, we are obliged as a public body, the FSCA, to comply fully with the tenets of the PAIA Act. Thanks, Shireen.
Thanks, Kamcilla. And I can actually support you in what you said about Ziyanda's big request, because I was a part in a very small group of providing information to that. And it was a very big request, and meant that we had to go through a lot of records. I almost wanted to say a ton of records. That's a bit of an exaggeration, but it almost felt like that. So yes, we do have to go through the records, make sure that we extract the correct information to them, provide it in the correct format as well, so that it makes sense to the recipient. So all my sympathy, ladies, it's a big issue. We're almost at the end of the question, and if you don't mind bearing with me, a last question, Ziyanda. I'm sure that sometimes there are complaints. So what happens if a requester has a complaint about this process? Do they have recourse? Can they do something about it?
Absolutely, Shireen. Section 77 of the Act gives a requester a right to lodge a complaint with the information regulator where, for example, his request for access to information has been refused and he feels aggrieved, or where an access fee has been imposed, or where the FSCA has extended the period within which it was required to respond to the request for one reason or the other. You'll recall that Kamcilla mentioned earlier that we are to respond within a 30-day period. And in certain circumstances, we do extend that period. So if a requester feels aggrieved by the extension, they are at liberty to approach the information regulator with a complaint. On receipt of the complaint, the information regulator will obviously make contact with us as deputy information officers, as we are contact persons for this purpose as well. And we obviously would provide a full record of the matter and give any answers to questions posed, so as to place the information officer, the information regulator, in a place where it can actually establish the true facts and ultimately come to a finding. The FSCA, needless to say, will always cooperate. So that's the complaints process, Shireen.
Thank you, Ziyanda, and I agree. We do take any questions, whether it's a question, a query, or a complaint, very seriously, and we do respond to that. I can certainly attest to that as well. Thank you so much for your time and unpacking this very tricky piece of legislation in a very understandable and easy to follow manner. I really appreciate your time and your energy, and all the best for your future requests. Any last thoughts from you?
Nothing from my side. Thank you, Shireen.
From my side as well. Thank you. Thank you to you too, Kamcilla.
Thank you so much. And I hope that our audience will tune in for further webinars. Thank you so much.